Hi, I'm Steve Carlson, and I am an Independence Party candidate for the United States Senate, running against the Democrat DFLer Al Franken in 2014. And I want to draw your attention to something that the Democrats are doing today, trying to repeal the First Amendment by giving themselves the power to stop parties who want to participate in federal or state elections from being able to get their message out. Now, I want to draw parallels with what Mark Ritchie has been doing, and I filed a lawsuit about this already. And I would like to call on people who are independent voters who identify with the Independence Party because they want a party to represent those who do not identify with either the Republicans or these Democrats who are now trying to repeal the First Amendment. I'm going to read what they're doing, and then I'm going to show you something about the case which I just won at the United States Supreme Court, and that is Carlson versus Mindeed et al., and that's Supreme Court number 138124. And I'm going to add that on the end, but I want you to see the parallels between what the Democrats are doing and what the Independence Party doesn't seem to think is wrong at all. We don't want a bunch of wishy-washy people who just attend an occasional meeting, but who are not ready to stand up and defend the United States Constitution, because without that, we cannot solve the very grave and difficult problems which our country faces, even as we are on the cusp of great opportunity. The vehicle is called SJ Res 19, Senate Joint Resolution 19. Quote, proposing an amendment to the Constitution of the United States relating to contributions and expenditures intended to affect elections. Now, this is actually authored and introduced by Amy Klobuchar. Now, she is a lawyer who should know better, and she's a Democrat, and what the Democrats are doing, using the Koch Brothers as a scapegoat, is to try to shut all of us down. Now, if you're aware of my case against Mark Ritchie himself took 12,000 email addresses home from his office to Secretary of State. Now, he's retiring, but he took 12,000 email addresses and used them to raise funds for his campaign and the Democrats' campaign. Yet Mark Ritchie has turned around and said no candidate has ever or can ever use those email addresses in an election except for him. And so I want you to be very aware of what these politicians can do if you give them the First Amendment to play with. So let's look at how they would amend it. This is the 113th Congress, SJ Res 19, proposing an amendment to the Constitution of the United States relating to expenditures intended to affect elections. So they want to affect elections by controlling the purse strings. Now, they held a hearing today, June 3rd, on this very amendment. And it's in the Senate of the United States, and it says this: Mr. Udall of New Mexico, for himself and others, including Ms. Klobuchar, he has introduced this and read it twice to the United States Senate, and they're trying to move on it. And it says, resolved by the Senate and House of Representatives, Democrats of the United States of America in Congress assembled, that the following article is proposed as an amendment to the Constitution of the United States, which shall be valid to all intents and purposes as part of the Constitution when ratified by the legislatures of 3/4 of the several states. Article, Section 1. To advance the fundamental principle of political equality for all, and remember, they could let everybody have the HAVA email addresses which we all submit voluntarily when we register to vote. And they could make this available to all candidates and have absolute political equality for all. But instead, they want to repeal the First Amendment. To advance the fundamental principle of political equality for all and protect the integrity of the legislative and electoral processes, Congress shall have the power to regulate the raising and spending of money and in-kind equivalents with respect to federal elections, including through setting limits on 1, the amount of contributions to candidates for nomination for election to for election to federal office, and the amount of funds that may be spent by, in support of, or in opposition to such candidates. What they would do is also in Section 2 give the same power to legislatures, many of which we know are controlled by redistricted arrangements where one party has absolute control of the legislature as they are redistricting the federal districts as well, and they would be able to control any money spent or in-kind donations or support of candidates for office. Now, I don't know about the Koch brothers. I know that they, as the Supreme Court has allowed, are supporting their positions. But I do know about these people. These people are anti-democratic, and they don't believe in the First Amendment. And Ted Cruz today asked for a liberal to stand up and defend the First Amendment. I'm as liberal as I am conservative. I believe in both principles, and I want First Amendment. This government must work. And you must pay attention to what's happening here and what is happening in the elections. It's not just about yourself or how oppressed you are or how you want to advance yourself over other genders or other races in the United States. This is about making our government work. And I ask you to pay attention to this, and I'm telling the independence candidates, they cannot sit back and watch this happen and say that they have any principles at all to defend for the Independence Party. Let the independent voters, 41% of Minnesota voters, come forth and support this Constitution and oppose this amendment by the Democrats.
Hello, this is Steve Carlson, the 2012 nominee for the U.S. House of Representatives against Betty McCall. And I want you to know that in addition to the conduct of Mark Ritchie and the Democrats in the 2012 election, which I have brought before the Minnesota Supreme Court and the Federal District Court of the District of Minnesota, I want to tell you a little story about what the state of Minnesota and its faceless bureaucrats and political leaders do to a person who dares to run against them and to criticize their policies. This is what they did to me. And this is before the 8th Circuit Court of Appeals. This is what I'm putting in my appeal brief, my appellant brief there. I think it's important. I hope you look at it.
There was no prior judicial review of the denial of EOC benefits in either STOI account, except for the two appeals as of right, defined and required by Minnesota Statutes 268.10 judicial review of the two ULJ unemployment law judge proceeding, each of which inexplicably concluded that the EOC statutes, quote, do not apply to Carlson, unquote, apparently meaning that Deed somehow concluded that I established each STOI account outside of the effective period of the new statute, which became effective July 22nd, 2010. This is impossible since I established these new accounts long after the new statute became effective on September 10th, 2010, nearly 2 months after, and December 5th, 2010, more than 4 months after. And so the statute applied to me in every sense of the word. And appellees compare my situation to Vogue versus Department of Employment and Economic Development, 794 Northwest 2nd, 662 from the Minnesota Court of Appeals, 2011, which Deed concluded a similar state statute requiring maintenance of 80% of weekly benefits when a new account was established and an applicant remained entitled to certain benefits did not apply to Vogue. But in that case, Vogue had already opened his new account 5 months prior to the date the new state statute became effective. In this case, I established my new account in question in Carlson 1, A11-254, nearly 2 months after the federal statute became effective. So there's no comparison. I did take appeal from the denial of each of these EUC accounts, but they were not the same because one involved payments from September 10th, 2010 to December 5th, 2010, and the other involved payments from December 5th, 2010 to December 5th, 2011. There were no payments for the first period and much reduced payments in the second because of the deprivation of the weekly benefit I had received through August 28, 2010, when the previous benefit year's account expired. The course of proceedings required for me to challenge this administrative decision was, for each period, to have a fact-finding, non-adversarial hearing directly with the ULJ on the phone, then to ask the same ULJ to reconsider their action, and then to appeal to the Minnesota Court of Appeals by the statutory process. This process, set out in Minnesota Statute 268.105, provides A. The Minnesota Court of Appeals must, by writ of certiorari to the Department, review the unemployment law judge's decision, provided a petition for the writ is filed with the court and a copy is served upon the unemployment law judge or the commissioner and any other party involved within 30 calendar days of the sending of the unemployment law judge's order under subdivision 2. There was no pre-deprivation notice or opportunity to be heard, and appellees have never contended that there was. In the first ULJ hearing, held about a month after the payments ended, the ULJ, saying he would not review the deprivation action but instead make a de novo finding of whether I was supposed to continue receiving the same weekly benefit amount of $293, refused to allow me to provide for the record the federal statute from 2008 that Valerie Woods, the deed appeal specialist, cited that required her, she said, to deny me the payments. He refused to identify the basis for the denial and deprivation of the payments. He said he could not give me an explanation of the action and that he had no constitutional authority, that is to say, to review whether my constitutional rights had been violated. In his ruling, he said only that the July 22, 2010 federal statute, which extended the payments to me as set out in the complaint at paragraphs 8 to 10, purportedly did not apply to me. This pretense has been repeated through all my attempts to secure payment and other remedies for this conduct by appellees. And so this remains the basic question in this case. Does the law apply to me if my accounts were opened in the effective period? And related, why weren't required procedural protections under the Constitution and the federal laws and even state laws followed? No answers at all have been given by any court. In A11-254, appellees failed to file a timely brief, but the time was extended. And then they filed a late brief saying the question was quote-unquote moot because I had closed the account. And as the Court of Appeals recounts it in their order and opinion, quote, D contends that this appeal is moot. Order and opinion by Chief Judge Matthew Johnson, quote, D contends that this appeal is moot because even if this court reversed the ULJ's decision, Carlson would be unable to benefit or obtain relief because, quote, the original account that was the subject of this appeal no longer exists. Carlson cannot receive any payment from it, unquote. Instead, Deed asserts that any benefits Carlson receives can only come from the December 2010 account and would be payable for periods after the effective date of that account. And that was the opinion of Chief Judge Johnson. But Chief Judge Matthew Johnson ruled that the statutes governing review, Minnesota Statutes 268-105, judicial review, would not allow such a ruling because it required review. Nonetheless, appellees persisted, ignoring the Chief Judge's ruling, and they found a more favorable judge, Stoneburner, whose ruling on December 23, 2012 is that the case was moot. That was improper, because it directly contradicted the panel that adjudicated that very issue, consisting of Chief Judge Johnson and Judges Wilhelmina Wright, now on the Minnesota Supreme Court, and Judge Stauber, with no chance for me to challenge or argue her arbitrary and unlawful decision. And she said the constitutional questions regarding procedure were irrelevant because she thought the plain meaning of the law denying me the benefits was so clear that the statute didn't apply to me. The order from Chief Judge Johnson is included in the record. It denies appellee's argument for mootness, saying, quote, a determination or amended determination of eligibility or ineligibility issued under section Minnesota Statutes 268.101 that was sent before the withdrawal of the benefit account remains in effect and is not voided by the withdrawal of the benefit account. Therefore, it's not moot, but this has been treated as moot because appellees, Governor Dayton, Lori Swanson, and the other individuals are attempting to bury this and then to exclude me forever from the federal courts. In other words, Appellees went to extraordinary lengths, even defying the Chief Judge of the Minnesota Court of Appeals, disrespecting the final decisions of Minnesota courts, to bury this and continue to injure me by cutting off benefits because of quote-unquote mootness, when that was not allowed by the law. And Judge Stoneburner violated the law of the case and state laws explained by Chief Judge Johnson, because she is a judge and she can do that. Now, although I did pursue the same required channels for the second account, the December 10th one that resulted in a second Minnesota Court of Appeals ruling that merely cited Stoneburger's unlawful, unconstitutional opinion. And as such, it merely clutters the record, in no way constitutes relitigation. For as the Chief Judge said, this is review of a, quote, determination or amended determination of eligibility or ineligibility issued under Minnesota Statutes 268.01, a totally separate proceeding required by law. About 1 month later, I filed the adversary proceeding to force the turnover of funds to the estate and an accounting, including why they hadn't been turned over already. This deprivation, plus other circumstances involving appellees, forced me into bankruptcy as my primary residence was about to be sold at sheriff's auction. Appellees forced me to continue working, if I was medically able, for $35 weekly for hard work of 15 hours per weekend, or they would terminate all benefits, which I wasn't receiving since my benefits were determined to be $0 payment. Appellant listed the claim for payment of these funds plus some damages as an exempt property on my bankruptcy forms. Filed the adversary proceeding to turn them over. The adversary proceeding was transferred to the district court, who assigned it to Magistrate Keys. He recommended the court abstain from the entire matter under the Younger Doctrine, dismissed the entire case. The recommendation was accepted and the final judgment entered December 5th, 2012. Although the district court did not discuss any of the bankruptcy issues and even denied it exercise bankruptcy jurisdiction after the transfer, it dismissed the entire case with prejudice and finality. The district court then went on to bar me forever from the protection of the federal courts in Minnesota as a, quote, danger to the federal courts, unquote. This, I contend, is uncivilized and not in accord with our cherished American constitutional rights. In addition, the magistrate has used this case as the basis for barring appellant from filing any federal cases myself, including even bankruptcy claims. His reasoning was that in the case under review in the instant appeal, Carlson asserted claims that were barred by the doctrine of res judicata, citing document 35 at 3 to 5, 14 to 15. Document 35 is the report recommendation, discussing overlap between Carlson's earlier state court lawsuits relating to his eligibility for certain unemployment benefits and the claims he sought to relitigate in federal court, and concluding that the federal lawsuit was barred by res judicata. This court recently recommended dismissal of those claims because Carlson litigated and lost the same issues he raised in the transferred case, unquote. The district court leads off with this case in justifying a permanent ban on my access to the federal courts. The statement of the case now, beginning with the nature of the case. This case was begun in the bankruptcy court as an adversary proceeding, complaint paragraphs 1 to 3, and transferred to the district court because it contained Article 3 claims with related to jurisdiction. The state brought a motion for judgment on the pleadings in the district court on the basis that because the case had been transferred based on related to jurisdiction, the district court bankruptcy jurisdiction of the case and jurisdiction over bankruptcy claims, that the claims were barred by the 11th Amendment, res judicata, and collateral estoppel, and that the Younger Doctrine required abstention. Instead of carrying out its bankruptcy duties, the magistrate dismissed all the claims as the state presented them and as he accepted them.